I am Dr. Harpreet Kaur from Army Institute of Law Mohali. Today I will be discussing with you the topic of concept of citizenship as per amended provisions of the Citizenship Act of 1955. Starting with the topic, the term citizenship refers to enjoyment of full membership of any community or state in which a citizen enjoys civil and political right. It can be defined as a legal relationship of an individual with a particular state, which is expressed by pledging his loyalty towards the state and by carrying out duties like paying of taxes, serving in the army during the need, respecting national principles and values, etc. The issue of citizenship in India is discussed in two places, that is the Constitution of India and under the Indian Citizenship Act of 1955. Article 5 to 11 of the Constitution of India deals with citizenship, which says those born before 1950 is per se a citizen of India. But the question of citizenship after 1950 or how anyone can acquire Indian citizenship is also of equal importance. These issues are discussed in Indian Citizenship Act of 1955. According to the 1955 Act, citizenship may be acquired through 5 methods. First is by birth in India, second is by descent, third is through registration, fourth is by naturalization and fifth is by incorporation of the territory into India. There was a prohibition on illegal migrants from acquiring Indian citizenship as per this act. The Citizenship Act of 1955 has undergone significant amendments over the years, reshaping the landscape of citizenship in India. The right of citizenship in India commenced only upon its independence. The British rule provided no such right in pre-independence era. Indians were provisionally classed as British subjects without citizenship under British Nationality Act. The partition of India in 1947 resulted a large-scale population movement across the new borders separating India and Pakistan. The people were liberated to reside in a country of their choice and acquire the nation's citizenship. In this context, the Constituent Assembly limited the scope of the Constitution citizenship provision for addressing the immediate purpose of determining the citizenship of these migrants. The Citizenship Act, later enacted by the Parliament in 1955, made a specific provision for the citizenship requirement and eligibility. The Citizenship Amendment Act of 2019, which created a furrow across the country, was passed by Indian Parliament on December 11, 2019 and it came into force on January 10, 2020. Citizenship is a legal relationship between an individual and his sovereign state, where individuals have the capacity to defend their rights in the front of government authority. The 2019 amendment gives citizenship to illegal migrant who belongs to these 6 communities, that is Hindus, Buddhist, Sikh, Christian, Jain and Parsi, and are from the 3 neighboring countries, that is Afghanistan, Pakistan and Bangladesh. This amendment is an issue because of religion is criteria for granting the citizenship and includes only religious minorities, not linguistic, ethical and other types of minority. Meaning of term citizenship. Citizenship signifies the relationship between individual and the state. Like any other modern state, India has 2 kinds of people, citizens and aliens. Citizens are full members of the Indian state and owe allegiance to it. They enjoy all civil and political rights. Citizenship is an idea of exclusion as it excludes non-citizens. There are two well-known principles for the grant of citizenship. While jus soli confers citizenship on the basis of place of birth and jus sanguinis gives recognition to blood ties. From the time of Motilal Nehru Committee in year 1928, the Indian leadership was in favor of the enlightened concept of jus soli. The racial idea of jus sanguinis was also rejected by Constituent Assembly as it was against the Indian ethos. Coming to the constitutional provisions for citizenship, the Constituent Assembly incorporated a generalized provision through Article 11 for the Parliament to regulate the citizenship by law. However, when it adopted the Constitution, it brought into force Part 2 of the Constitution for citizenship, with Article 5 to 11 dealing which state as follow. Article 5 states that every person who has a domicile in the territory of India and who was born in the territory of India, or either of his parents were born in the territory of India, or who has been ordinarily resident in the territory of India for not less than 5 years immediately preceding such commencement shall be a citizen of India. Coming to Article 6 of the Constitution, rights of citizenship of certain persons who have migrated to India from the territory now included in Pakistan shall be deemed to be a citizen of India at the commencement of this Constitution. Article 7 states rights of the citizenship of certain migrants to Pakistan is a special provision for persons who have migrated to Pakistan after 1st March 1947 but returned to India subsequently. Article 8 of the Constitution states that these are the rights of citizenship of certain persons of Indian origin residing outside India for the purpose of employment, education and marriage. Article 9 states that persons who are voluntarily acquire the citizenship of a foreign state will not be a citizen of India. Article 10 states that every person who is a citizen of India under any provision of this part will be subjected to any law enacted by the Parliament. Now, I will be discussing with you the Citizenship Act of 1955. The Citizenship Act of 1955 is a fundamental legislation in India that governs citizenship related matters. It outlines the criteria and procedure for acquiring, renouncing or terminating citizenship. Following in the summary of the Citizenship Act of 1955, first is citizenship by birth, which is given under section 3. Individuals born in India on or after January 26, 1950 are citizens by birth. Section 3 elaborates on the conditions and exceptions relating to citizenship by birth. Citizenship by descent, section 4. Section 4 deals with citizenship by descent. Individual born outside India are citizen by descent if their father was an Indian citizen at the time of their birth. This section provides the conditions and qualification for citizenship by descent. Citizenship by registration, section 5. Section 5 outlines the provision for citizenship by registration. Foreigners not eligible for citizenship by descent can acquire Indian citizenship through registration. It specifies the eligibility criteria and procedure for registration. Citizenship by naturalization is given under section 6. Section 6 discusses citizenship by naturalization. Foreigners can become Indian citizen through naturalization if they meet certain residency requirements, are of good character and fulfill other conditions specified in this section. Renunciation and termination of citizenship is given from section 8 to 10. Section 8 to 10 deals with renunciation and termination of citizenship. Indian citizens can renounce their citizenship voluntarily. Citizenship can also be terminated under specific circumstances such as acquiring citizenship of another country or engaging in activities prejudicial to the interest of India. Authorities of citizenship matters is given under section 16 to 17. Section 16 and 17 establish authorities responsible for citizenship matters. These includes the central government, which has the power to grant, renounce or terminate the citizenship, and specified officers who assist in their processes. These sections collectively provide the legal framework for determining citizenship in India, ensuring clarity and consistency in citizenship related issues. I will be discussing with you the important amendments. The Citizenship Amendment Act of 1986. Unlike the constitutional provisions and the original Citizenship Act that gave citizenship on principle of jus soli to everyone born in India, the 1986 amendment to section 3 was less inclusive, as it added the condition that those who were born in India on or after January 26, 1950, but before July 1, 1987 shall be an Indian citizen. Those born after July 1, 1987 and before December 4, 2003, in addition to one's own birth in India, can be citizenship only if either of his parents was an Indian citizen at the time of his birth. Second amendment is the Citizenship Amendment Act of 1992. According to this act, any person born outside India is considered a citizen of India by virtue of citizenship by descent if either of the parents was a citizen at the time of his birth. Next amendment is the Citizenship Amendment Act of 2003. The amendment made the above condition more stringent, keeping in view infiltration from Bangladesh. Now, the law requires that for those born on or after December 4, 2004, in addition to the fact of their own birth, both parents should be Indian citizens, or one parent must be an Indian citizen and other should be non-legal migrant. With these restrictive amendments, India has almost moved towards the narrow principle of jus sanguinis or blood relationship. This lays down that an illegal migrant cannot claim citizenship by naturalization or registration even if he has been resident of India for 7 years. The Citizenship Amendment Act of 2015. The Citizenship Amendment Act of 2015 has modified the provisions pertaining to the overseas citizen of India in the Principal Act. It introduced a new scheme called Overseas Citizen of India card holder by merging the Persons of India origin card scheme and the OCI card scheme. Next, coming to the most important and the latest amendment, that is the Citizenship Amendment Act of 2019. The amendment proposes to permit members of 6 communities: Hindus, Sikh, Buddhist, Jain, Parsi and Christian from country of Pakistan, Bangladesh and Afghanistan to continue to live in India if they have entered India before 31st December 2014. It also reduces the requirement for citizenship from 11 years to just 5 years. 2 notification also exempted these migrants from Passport Act and Foreigners Act. A large number of organizations in Assam protested against this bill as it may grant citizenship to Bangladeshi Hindu illegal migrants. The justification given for the bill is that Hindus and Buddhists are minorities in Bangladesh and fled to India to avoid religious persecutions, but Muslims are a majority in Bangladesh and so the same cannot be said about them. Now discussing the Citizenship Amendment Act of 2019, its key features. The Citizenship Amendment Act of 2019 seeks to provide Indian citizenship to illegal migrants who are Hindu, Buddhist, Sikh, Christian, Jain and Parsi and coming from Pakistan and Afghanistan. There is no use of word persecution in the Amendment Act. For this, the 2019 Act changes the way of acquiring citizenship according to the Citizenship Act 1955 by changing the definition of illegal immigrants and the process of acquiring citizenship. Change the definition of illegal migrant. Migrant means if any person leaves his country and start living in other country permanently, then he is an immigrant for that nation. Till now, illegal migrant defined in the Principal Act as if any person who comes to India for living without having a valid passport or having fraud document or he has exceeded the permission limit of staying in India. In that case, that person will be called as illegal immigrant and he will be forced to leave the country. But this Amendment Act inserted a proviso in the definition clause and says that before 31st December 2014, any people who have come to India by ways and if they are from 3 countries, that is Pakistan, Afghanistan and Bangladesh, and they belong to these 6 communities, that is Hindu, Sikh, Buddhist, Jain, Parsi and Christian, shall not be called as illegal immigrants. They will not be deported as illegal immigrants under the Passport Act of 1920 and Foreigner Act of 1946. Such person shall be deemed to be citizen of India from the date of entry into India and all the legal proceedings against them in respect of their illegal migration or citizenship will be closed. The changes in the process of acquiring citizenship. Before, it was like if you are coming from Pakistan and willing to take Indian citizenship, so for that you have to spend 11 years in India or you have to do any government service and after that you will get the Indian citizenship. The Amendment Act changes the whole process and says that if you are from Pakistan, Bangladesh and Afghanistan and belongs to Hindu, Sikh, Buddhist, Jain, Parsi and Christian from these countries, you have to spend only 5 years instead of 11 years to get the Indian citizenship. The amendment on the citizenship for illegal immigrants will not apply on 2 categories. First is state protected by inner line and second is areas covered under the 6th schedule of the Constitution. Now, I will be discussing with you Citizenship Amendment Act 2019 and its constitutional validity. If one interprets Citizenship Amendment Act 2019 in the light of essence of that law and a sense of the grand norm, that is the Constitution of India, the objective is to give the Indian citizenship to persecuted minorities, either it is religious or linguistic or ethnic from the neighboring countries. It means who had suffered religious as well as linguistic persecution or fear of religious as well as linguistic persecution in their country of origin are eligible to Indian citizenship. The soul of the amendment is to give citizenship to persecuted minorities. Why? Because they suffer enormously in their country. Minorities are subject to discrimination, humiliation and persecution while majority enjoy special rights and privileges. Many have been forcibly converted and women belonging to minority communities have been kidnapped, raped and forced into marriage with the majority. The spirit is to set an example for other countries that India stand with all the persecuted minorities of all neighboring countries irrespective of their religion and language, and we are against all kind of discrimination, humiliation and persecution. We will not sideline the rights of the minority. The purpose of bringing amendment is to give more secure and dignified life to persecuted minorities by giving them Indian citizenship that would enable them to secure admissions in educational institutions, get jobs, buy property and enjoy state welfare benefits. It clearly shows to other countries that India is fully against any kind of discrimination and they all have freedom of thought, conscience and religion. They all have right to freely profess, practice and propagate their religion and right to conserve their distinct language, script and culture. But there are contrasting views also. This Amendment Act is against the essence of this law and grand norm, as it gives citizenship on the basis of religion, which belongs to selected countries. Article 14 deals with equality before law and equal protection of law. This equality and protection apply equally to both citizens and foreigners. It clearly said there can't be any discrimination between individuals on any unreasonable grounds. There should be an equal treatment between individuals and the law should apply equally upon all. Article 14 permits reasonable classification only and it forbids class legislation. So, reasonable classification is constitutionally permissible as the law can apply equally only upon the persons who are equally placed with respect to the purpose of that law, and for the purpose the test of reasonable intelligible differentia has to be applied. However, class legislation in itself is arbitrary, discriminatory and against the principle of natural justice. The question is whether this Amendment Act violates Article 14 and the spirit of the Constitution, as it gives a different treatment to illegal migrant on the basis of country of origin and their religion, the date of entry into India and the place of residence in India. So, there is a need to examine whether these differentiating factors could fall in reasonable classification or not. It means whether they could serve a rational purpose for classification. Now, firstly, this Amendment Act classifies the illegal migrant on the basis of their country of origin, which include Afghanistan, Pakistan and Bangladesh. We have limited resources, so it is not possible to include all the countries of the world. The question is why only these 3 neighboring countries were included and not all the neighboring countries. According to the statement of objects and reasons, India has had historic migration of people with Afghanistan, Pakistan and Bangladesh, and these countries have a state religion due to which there is a religious persecution of minorities, but they did not consider the migrants from other neighboring countries such as Sri Lanka, where Buddhist is the state religion, and Myanmar, where preference is given to Buddhist. Sri Lanka has had a history of persecution of linguistic minorities. The Tamil, Alams and Myanmar also had a history of persecution of religious minorities. The Rohingya Muslims, the Act does not cover Rohingya Muslim refugees from Myanmar, Hindu refugees from Sri Lanka and Buddhist refugees from the Tibet of China. So, it is not clear why they have been excluded from the Act, despite the objective of the Act is to provide citizenship to migrant escaping from religious persecution. It is not clear in the considered opinion of the author as to why migrants from Pakistan, Afghanistan and Bangladesh are differentiated from the migrants from other neighboring countries. all persecution is solely based on religious ground and do not cover the persecution on the basis of ethnicity, linguistic, etc. This act does not cover the ethnic issue of Balochs, Sindhis, Pakhtuns, Mohajis in Pakistan, the Biharis in Bangladesh, ethnic and linguistic issues of Tamils in Sri Lanka and ethnic Indians in Malaysia and Fiji who migrated there in search of work or brought therein as independent laborer when those were British colonies. Further, there is no reason to include Afghanistan, while there is a reason that millions of citizens of undivided India were living in Pakistan and Bangladesh. Second, there is a classification based on their religion. According to SOR, there is a religious persecution of minorities in Pakistan, Afghanistan and Bangladesh. It is absolutely true, but the Act considers only certain minorities, that is Hindu, Sikh, Buddhist, Jain, Parsis and Christians. There are other religious as well as linguistic minorities also who face religious persecutions and they may have illegally migrated to India, but there is no cognizance on this. This act only includes certain religious persecutions, not include linguistic and other religious persecutions. It should have included Ahmadiyas, a Muslim sect who have been viciously hounded in Pakistan as heretics, and the Hazras and other Muslim sects who have been murdered by Taliban in Afghanistan. They should be treated as minorities. In Pakistan, Ahmadiyya Muslims are considered non-Muslims and there has been report of their persecution and the murder of atheists in Bangladesh. Third, there is a differential treatment of migrants based on their date of entry in India, that is, whether they entered India before or after December 31st, 2014. If you are from Pakistan, Afghanistan and Bangladesh and you belong to Hindu, Sikh, Buddhist, Jain, Parsi and Christian from these countries, then you have to spend only 5 years to get Indian citizenship. But if you are a Muslim, you have to spend 11 years. It is not clear what is rational behind this and why likes cannot be treated alike. Hence, there is no reasonable classification and it seems to violate Article 14 of the Constitution. It divides the migrants on the basis of religion that compromises the Constitution's basic structure, that is the secularism. It seems to make a line between Muslim and non-Muslims which compromises the concept of fraternity and unity and integrity of the nation. The real test is to examine the sense of law and to see whether the law provides unreasonable and arbitrary powers. The moment it is found to be arbitrary, the law itself would be struck down as being unconstitutional, even though it makes reasonable classification. After Keshwananda Bharti versus State of Kerala, 1973 Supreme Court cases, page number 225 judgment, the entire perception regarding constitutional interpretation is changed, and now the test is that legality of any legal provision is to be checked in the light of essence of that law and the essence of the Constitution. This amendment also seems to violate India's international obligation. Article 14 of UDHR clearly said everyone has the right to seek and to enjoy in other countries asylum and persecution, and according to Article 15, everyone has right to a nationality and no one shall be arbitrarily deprived of his nationality nor denied the right to change his nationality. According to Article 26 of ICCPR says all persons are equal before law and are entitled to equal protection of the law without any discrimination. There should be no discrimination on any grounds such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth or other status. Concluding this topic, it must be pointed out that the national spirit of providing shelter and sanctuary to the refugees is not new. In fact, India has a long history of doing so for the victims of persecution. Whether it is the Zoroastrians in the 12th century or the recent Tibetans, India has always demonstrated humanity and generosity and has opened its arm to those who seek asylum. The act must be viewed with a positive eye to legitimize its existence as an asylum seeker in India. However, just as bitterness and cruelty are not partial to certain people, we cannot favor our generosity. The law should also find ways to accommodate Ahmadiyas, Uyghurs and Rohingyas who are also persecuted ethnic minorities and have knocked on the doors of India when needed. We must reason and discover what citizenship really means. Citizenship is not only a legal tie between the state and the individual, but also reflect a sense of belongingness and yearning. The Amendment Act addresses people who are eager to live in an environment that free from the fear of persecution and those who can imagine a better future for themselves. This Amendment Act fulfills the spirit of our Constitution if it does not discriminate persecuted minorities on the basis of religion, and if all kind of persecuted minorities of the neighboring countries are eligible for Indian citizenship irrespective of their religion. I hope you found this lecture to be useful. Thank you and have a nice day.